Good afternoon, everyone. Today is March 21st, 2024, and this is the Know Your Rights webinar, and you are in the personal injury breakout room. All right, so today we will be giving you an overview of your rights in California if you've suffered from a personal injury. We will go over what personal injury cases are, go over the types of damages that can be claimed, the life of a claim and litigation, and if we have some time, go over some case examples. At the end, we will also have some time for questions if you have any. This session is going to be recorded and available on FBANC's YouTube channel. Given that, we will save all the questions to the end. All right. Before we begin, just to be clear, this presentation is a general information presentation. It's not meant to be legal advice. I'm not going to be talking about anyone's particular case today or telling anyone what to do specifically. So, with that said, I'm going to leave this waiver on here on the screen for just a second longer. Now let me introduce myself. My name is Isabelle. I was born and raised in the Philippines, but finished high school in Union City. I went to undergrad at UC Berkeley and went to law school in Loyola Law School in Los Angeles. I am a personal injury attorney practicing plaintiff side litigation for over 11 years. This means that I only represent the people who have been injured in personal injury cases. I currently work for Arash Law Injury Attorneys, and our firm handles many catastrophic personal injury and workers' compensation cases. I have worked on hundreds and hundreds of personal injury cases and have seen everything from a simple rear ender to lost limbs, traumatic brain injuries, and even death. Before I move forward, actually, let me allow my colleague, Ms. Torres, to also introduce herself.
Hi, thank
Go
you.
ahead.
So my name is Roseanne Torres. Everyone calls me Rosie, and I have been practicing law in Oakland with my own firm, Torres Law Group, since 2004, March 2004. Prior to that, I had 4 years of work experience in government. I was a deputy county counsel. I represented county agencies in San Joaquin. And then I transferred over to criminal law, and I was a deputy district attorney, or what we call a prosecutor. Then after 4 years, I went into my own practice. And right now I handle personal injury of all types. And you're going to hear more in a little bit.
All right. Thanks, Rosie.
Welcome.
So, what is personal injury? Well, it's in the name, right? It's an injury to your person, meaning your body, your mind, your emotions. This also applies in a wrongful death matter. It's different from, say, a damage to property or something that, arises out of a breach of contract or any other type of legal dispute. It really is a matter about whether your body, your mind, or your emotions have been injured through the actions of another. So I have a 4-year-old, and I find myself constantly saying, be careful. If you pay attention, then we won't have any accidents. And in essence, that is what negligence is. And personal injury cases usually arise out of negligence. So basically, what is negligence? Well, we all have a duty to be careful in our actions so that we don't cause harm to someone else, right? So for example, we have to be careful when we're driving, right? Because when we are negligent, we could cause a crash and injure another person. A personal injury case arises when you believe that someone else's fault whether it was their negligence, their reckless conduct, an intentional misconduct, has caused you injury to your body, your mind, and or your emotions. Here are some examples of personal injury cases. All right. The most common one is a motor vehicle crash, right? Two cars crashing into each other, or a pedestrian getting hit by a car, a bicyclist being hit, a motorcyclist being hit. Those are some of the more common personal injury cases. Another one could be if, someone runs the red light and causes a crash. A driver isn't looking out for a pedestrian before making a right turn. Those are very common personal injury cases. Slip and fall or trip and fall cases are generally considered premises liability cases as well, meaning that a person who owns property has a duty to make sure it's safe. So if, for example, there's a spill in a grocery store, and you slip and fall and say you break your hip, that's a personal injury. If the stairs at a winery are broken and you fall and you're injured, that's also a personal injury case. Another type is dog bites. You may not know it, but if you're bitten by a dog, that is definitely a personal injury case. Medical malpractice is another type. So for example, in an extreme case, if your doctor is not paying attention when he's treating you, then, and it causes you further injury and in some cases death, that is also a type of personal injury case. Products liability is another type of personal injury case too. So this happens when a person is injured because a product was deemed defective. A well-known example of that would be the asbestos cases, right? So a long time ago, people used asbestos in their products and it caused injury to a lot of people. That's one example of a product liability case. Another one that's more common and more recent are like the Takata airbags in cars, when the airbags would just deploy all of a sudden and cause accidents, or throw shrapnel when it deployed and caused injury. Another thing you might not know is that you could sue the government for personal injury. In some cases, they're called dangerous conditions on public property. That's one way to sue the government. Sometimes it could be because a government actor has caused you an injury, right? So someone who works for the government. A dangerous condition of public property is like premises liability, but focuses on public or government-owned property. So for example, a roadway, right? If you find that a roadway is dangerous, given, for example, that there is blind curves and it's been causing a lot of accidents or injuries, that could be a basis for a dangerous condition on public property case. Now, I want you to understand that each one of these are nuanced. They're not all exactly the same, and there's different laws that control each one of them. But this is an overview so that you understand when you are injured, or if someone you know gets injured, that you might have a personal injury case. Now, there are many, many more types of them, but these are some of the more common ones that, we see in our practice. Now, in order to have a personal injury case, not only do you have to say that someone else did something, that was negligent, but you must be able to show that their act of negligence caused you some damages. Now, there are two main types of damages that you can make a specific claim for in a personal injury case. One is what we call economic damages, right? Just in the name alone, it means that it's something that you can calculate. These are usually medical bills, lost wages, your inability to work in the future, your future medical bills, and things like that. So anything that you could possibly calculate, those are considered economic damages. The second type of damage is called non-economic damages, right? These are what you've heard possibly on TV as pain and suffering damages, right? So this is called emotional distress, anxiety. These damages are not easily calculated because how can I say that 1 minute of excruciating pain because I broke my arm is worth $1,000 versus someone who watched a loved one get injured in a car crash directly in front of them? How much is that pain and suffering and emotional distress worth? Those are usually what we are considered non-economic damages. It's not really a fixed value. And these are the damages that I like to think of as the human cost, right? We have these damages because we're human, because we have to go through life even though we've been injured. So those are the things that we believe having an attorney would really be beneficial. So we can make sure that they see the whole of your injury and it's not really just about medical bills or lost wages. Now, there are other damages that you can ask for from the court or the jury too. I'm sure that many of you have heard of verdicts that are astronomical. Other types of damages I've asked for are something like a personal apology. Sometimes you can ask for a personal apology because, you know, it does go a long way. Sometimes you can ask for an injunctive relief, meaning that as part of the case, as part of any settlement, that a person or a company stop doing something. For example, in a case against a golf course, we made sure that as part of the settlement that they fixed what was the cause of my client's injury. So those are some things that you can also do. Now I'm going to hand the baton over to Miss Torres, who's going to go over what it's like to open a claim, a personal injury claim. I'm going to stop sharing my screen and allow Rosie to share her screen.
I go by Rosie, and I'm going to continue with regard to where we've just left off, probably a little bit repetitive, but again, as a former prosecutor and former county counsel, I did civil and then criminal law, and now I do personal injury here in Oakland. And the next steps, now that you understand what some of the basics are of personal injury, and of course, Isabelle can't cover every kind of case that can fall under personal injury because there's many, many kind, but she definitely covered a good majority of what attorneys see. And so people wonder, well, what do I do when I have a personal injury case? So you find yourself in that position, and there's a few things that are at the top of the list, and you want to understand those clearly. The first one is that you're opening up something called a claim. So the first step is you're making a claim in your personal injury case with the insurance company. And I'll give the simple example of a car accident. Most people have this in their environment when they get in an accident, and they basically have to get out, take a picture of the other person's insurance policy, probably that person's license, which has their photo, their address and everything. And they also would give their own, because even if you're the one who's the victim and you're injured, you want this person to have your information and you're going to exchange. So after you get that person's policy, let's say it's farmer's insurance, and you saw the policy number that they have for that car they're driving, presumably, and it's a real policy and it's not fake. We did see a lot of fake things in COVID, unfortunately. Then you would call that company, and how you would find out where to call to make your claim is you would Google farmers insurance, and you will find right away, and for every insurance company, how to make a claim. Here's the 800 number. and they will have people in different languages. So if you don't speak English, there will be other people in the company. They're huge. Most of these companies can take your claim in a multitude of languages. The claim is going to be done in about 10 minutes. You're going to say, this is where I was driving, this is what happened, and this is my driver's license and insurance information, and I'm injured. So a personal injury case is a person who's injured. It's not a person who just has some bumper damage. As law firms, we don't necessarily handle the property damage. The property damage is really a separate claim. We're talking about personal injury, the body is injured. So you make a claim, you might tell this claims person on the 800 number that you are feeling, weak, or your seatbelt strap has left you burned with pain and a bruise. However, you're injured. You're not a doctor either. So you're giving them some general description in this claim. I also have a couple of clients that were here and they did it online. I gave them a laptop. They opened their claim, and the best way they felt more comfortable was just doing everything online, which was uploading a photo of the driver's license, the policy, and they're doing it against the driver that hit them. So online, on the phone, those are the two ways. Then you end up getting a letter right away that tells you this is your claim number, and that's like your social security number in this personal injury case, because Farmers has millions of claims because their drivers are hitting people I think it's every 6 minutes in this country, there's an accident or some statistic like that. It's pretty regular, it's pretty frequent. The other people you want to make a claim with, however, and this is very important, and I'll explain why, you want to make a claim with your own insurance policy for your vehicle, because there are times when we're working with clients and we find out that the person got out, gave them a picture of their policy, their driver's license. You then call, make the claim, and that person just takes the information. They don't really have any way to see if that insurance is valid. So you have opened up a valid claim. You get a letter in 2 or 3 days. Hi, this is your claim number at Farmers. I'm the adjuster. 30 days later, you might get this other really scary letter, which says, uh-oh, the driver that hit you hadn't paid his insurance and he was not insured the day you crashed. He crashed into you. So now you have a claim that isn't going to necessarily go anywhere because the person wasn't validly insured that day. It's happened to a couple of my clients. Again, it's become more frequent during COVID. I have a theory, which is that people weren't allowed to go anywhere. We were not driving. We were stuck at home. And we also saw millions of Americans lost their jobs. Well, if you're not driving and you don't have a job, probably one of the first bills that people might have said, I can't afford to pay, is my car insurance because I'm not going to work anymore. Unfortunately, that leads to a lot of claims that were then rejected. So then if you have the claim with your own policy, the biggest important thing you should learn from this talk, in my opinion, because I have friends pull out their policies while we're having dinner parties and they change it right there, which is something called uninsured coverage. If you have uninsured coverage or underinsured coverage, which is a line on your insurance policy declaration page, a declaration page is how much insurance did you buy for liability, property damage? Did you buy medical coverage? Did you buy rental car insurance? And then what did you buy for bodily injury? So if you're at fault and you hit someone and you bought a certain amount of insurance, say you caused bodily injury and you were the negligent driver, the one at fault, and you bought 50,000 over 100,000, that's what that person's going to get. But the most important line, I feel, especially the way people drive in the Bay Area, everyone's in a hurry, is uninsured coverage. Underinsured coverage, we call it UIM, it's the same thing, and it's way down at the bottom after bodily injury, liability, property damage, medical payment, and rental car. And if you have a 0 next to uninsured motorist coverage, that's a problem. And I'll tell you, the last weekend, all my friends at the dinner party checked and they had $100,000 minimum of uninsured coverage, which protects us for buying that, for having that extra step of insurance. If I get hit by an uninsured driver over there who stopped paying his bill, but he's driving around with a piece of paper so the police won't arrest him, then I have 100,000 I can get from my insurance. And it's wonderful because a majority of my cases in COVID turned out to be uninsured motorists. I have clients who have 250, 500,000, 300,000, and it makes me so happy that their insurance agent was giving them the best product that's on the market. And it's usually under $100 for something like 100,000 or 250,000. It is really, really the best amount of money you could ever spend. I can beat that forever because with a dead horse, because it's so valuable for the cost. So those two claims, claim for the other driver, claim of your own policy, uninsured motorist will save you. You already heard about damages. If you miss 6 months of work and you make $100,000, that's equivalent to $50,000. If you got 100,000 of uninsured motorists at least, and the other driver had 0, you're going to get paid at least your lost wages. Some of your medical bills will get paid, and some of your pain and suffering is going to be wrapped up in that extra 50,000. But my God, if you don't have it, and that other driver illegally drove without insurance, it's the hardest call we have to make as lawyers. Calling a client to say, I have some bad news, right? We don't know when we start a case what all is going to come at us, but it starts to come out in the first 30, 45 days. And we sometimes have to make that really sad phone call that your medical bills aren't going to get paid. Your lost wages aren't going to get covered. Unfortunately, this person was lying. Then we have the next stage. So if you should find yourself in the good company of a personal injury lawyer and you've made your claims, you would bring those letters that you've been receiving from the insurance companies, and they're going to be letters from both companies, to the lawyer, because what happens is that they're going to send a lot of letters. They're going to ask you for your treatment, what's going on with your doctors, are you treating, when are you going to be done? They're going to ask about wage loss. They're going to ask you about those things in the letters, and they're going to make it seem urgent. Send in your medical records, send in your wage loss, and you just getting started. When you have a car accident, maybe 2 months into it, you're still just getting your doctor to refer you to a specialist or to get an MRI, because they're not just giving those out like candy. MRIs are expensive, so they don't just send you there. So if you're getting overwhelmed as a client because you're getting all these letters, which are just being spit out by a computer, it's not a human being saying, I need this. It's a computerized system to inundate you and overwhelm you, and also cause, I think, a little bit of fear. My clients are really afraid because they haven't been responding. And once you get the lawyer's going to handle that paperwork, and your job, your number one job, is going to be get to those doctor's appointments, get to those specialists, get to that chiropractor, that physical therapist. There's a majority of these cases, there's many different types of treatment. So one treatment is not a one-stop shop. The chiropractor is not typically going to fix everything. A physical therapist isn't going to fix everything. So you're creating a calendar with all these appointments, and it's overwhelming. Clients say, I struggled to keep up with, I had to go see my doctor to get referred to this, and that doctor referred me to this. And so they're struggling, and then they're getting the letters from the insurance companies, and they don't know what to do with all those requests for information, requests for medical records. So when you have the lawyer's handling the other side of all that paperwork. You complete your treatment. It can be months, and sometimes it can be years. And as you heard Isabelle talk about the more catastrophic injuries, there are clients that we as lawyers have that treat beyond a year, beyond 2 years. And that means we're not rushing you. We're saying you treat, we'll keep the insurance company happy with updates, but very limited information, because they only get what we want them to have as lawyers until we're ready for the final stage of your claim. And the final stage of the claim, if you finish treating and you had, say, a shoulder, a neck, and a upper back injury from the seatbelt, and you snapped and you hit your head on the steering wheel, you might treat for 6 months with a variety of modalities, the chiropractor, physical therapy, what have you. We order all those records as lawyers. We order all those bills. We also get all your wage loss. We get photos of your injuries, your bruises, what have you. Then we're at the final stage of potentially settling your claim with a demand packet, which is going to be all the documents they've been asking for. So if we can settle your claim, you're doing great, because that's pretty fast. If we can settle your claim in 6 months, a year, because you're done treating, we got everything lined up, and we could be going against your own policy as an uninsured motorist claim, which I was talking about. However, insurance companies, since I started my firm 20 years ago, have made the process steeper and steeper and steeper. And in COVID, they went a little steeper. I started hearing clients, adjusters at opposing insurance companies say, I want 2 years of your client's medical records pre-crash. I want 4 years. I want this. I want that. And I don't always oblige, because they don't always have the right to have everything that they're asking for. They're fishing to see how much we'll give them as lawyers. And I know Isabelle will agree. So, 20 years ago, they didn't do that. I would settle cases pretty early on after the claim stage and the client finished treating. Now, unfortunately, we get to this next step more often than not, which is called litigation. And litigation is when you actually have to file what's called a summons and a complaint in the court, typically in the county where you had the accident. It's a lot of nuances in this area too. So you file this lawsuit against the driver, provided that there is insurance.
And Rosie, can I just step in briefly?
Yes, absolutely.
I just want to also bring up the idea that litigation is basically when you file the lawsuit, but there is a thing called the statute of limitations, right? It means that you can't wait forever to make a claim for the injuries that you suffered from any crash, any fall, or a medical malpractice lawsuit, anything. So do not wait. Typically, a personal injury case has a 2-year statute of limitations in California. If it involves the government, it's as short as 6 months. If it's a medical malpractice, it's as short as 1 year. So those are things that you also need to think about. You don't have a lot of time to wait and decide if you want to. It's so much easier to just go ahead, hire the lawyer, and then make a decision whether you want to start the litigation process or not when it's time. But the lawyer will keep track of the statute of limitations.
That's correct. And that's something that lawyers in this type of practice must know. And however, I have represented people that went to lawyers, and that person might have been an immigration or a family law attorney, and they did not bother to tell the person that very basic knowledge about 2-year statute of limitation. I had a young boy with a dog bite case. He and his mother were bit. Now, if you're a minor, it's different because you have to be 18. The max of the statute of limitation is 2 years from his 18th birthday, or he can sue as a child, and he was 7. But his mother, she only had 2 years. So it's complicated. They don't have the same rule as a minor and a mother. And I've also had people come to me, and this lawyer that they spoke to in Richmond didn't tell them, and mother's statute had run. So I only got to help the child who was bit by the dog in the neighborhood. Mother was also bit trying to get the dog off, but she had no recourse because it was 1 month too late when she called me. That first lawyer never told her about the timeline, and it was still within 6 or 7 months. So we hear that again. It's such a hard thing to sit from across the room from someone and say, this is too late. And the government claim, I can tell you in our world as lawyers, 6 months is like a blink of an eye. It goes so fast. So the sooner you talk to a lawyer, if you think you have been injured by someone who can be held responsible and you are truly suffering and pain and injured, talk to a lawyer. We don't charge. Personal injury lawyers, we don't charge you like you would be charged with other civil lawyers that have an hourly fee schedule. In the Bay Area, it can be as high as $850. I was doing family law many years ago, and there was a lawyer charging $650. I was charging $450, and it was just shocking to me, but it is what it is. We don't charge by the hour because we get paid in a different way, which is when we win your case. That's not what happens. So you can call, get some advice. It is free. Always try to get some advice. The discovery process, I'm going to go on to my next bullet. In regard to filing the lawsuit, you now have taken on a more aggressive stance to the extent that at the claim stage, the defense insurance, the farmers, for instance, as I was giving an example of a car crash, the claims adjuster who you're talking to as a lawyer, or if you were still doing it by yourself, that claims adjuster has a limit of money that they can give you. And they really get rewarded for giving you a lot less. So as a result, if they do not want to be fair, and if they do not value the case the way it should be valued according to you and all the treatment and all the suffering and what your lawyer also thinks, because your lawyer is going to have experience and they're going to probably tell you, I think your case is between this much and this much. No one has a crystal ball, but your lawyer is going to tell you that. If the adjuster is way below that, you're going to go to litigation, filing the lawsuit. But I also tell clients, it's not that you're suing the guy who drove John Smith. You're suing the policy that Farmers has where the pot of money's at, right? Because clients are afraid to sue, especially if it's a little old lady, right? Maybe she shouldn't be driving anymore and maybe she has some vision issues. Sometimes the injured clients don't want to sue somebody because they feel bad and they say, gosh, but she's an old lady and so on. You're going after the insurance company. It names her, but you're going after the policy. So you shouldn't feel bad. You should just talk to a lawyer and get some advice, and they'll explain this to you in detail. The discovery process begins after the lawsuit has been given to the other side, what's called the defendant. The person injured is called a plaintiff. You may have heard those in other contexts. Criminal court, the state of California is the plaintiff, and the defendant is the person arrested for a crime. So plaintiff, defendant, similar to a criminal case, as in a personal injury case. You're the plaintiff as the injured party. You have to give the lawsuit to the other driver. The other driver will then give it to the insurance company. The millions of lawyers they have will then start fighting on their behalf and doing some research as to your injuries. And that's called discovery. They're discovering through this process, what are your medical bills? What is your treatment? Is there anything in your medical records that says, not only did you get hurt in the crash, but within a week of the crash, you were riding your brand new skateboard, you fell back and you hurt yourself. And now they're going to say, wait, we're not paying for that. We're not paying for that, which is your back, and you were hurt in the car accident in your back. So they're going to start, splitting apart the different things that have happened to you when they start looking into your records. However, most of the time, people who are injured are not riding a skateboard. So just an example that as lawyers, we have to be thorough. And if your lawyer is also asking you all of the questions, do you have hobbies? What's going on with you besides, recovering? Maybe you do have sports that you play, and maybe you do have rough hobbies. I mean, people obviously ski and snowboard. Those are things that your lawyer should know, because we want to know how active you are and if you're getting hurt in other ways, because it's going to probably come out in the records if you went to a clinic after a bad fall on the slopes. Then that process of discovery is pretty lengthy. It varies depending on the case. But what the whole point of litigation from a lawyer's standpoint is that it's a preparation very slowly on both sides towards going to trial. That's what it is. Preparing for trial and presenting your story presenting your case to the public in the form of the jury, 12 members of the jury. So these are people from your society, from your neighborhood, could be eating at the same coffee shop you go to, the same Starbucks, Pete's Coffee. Really, they should be people who look like you, who live like you. And it's difficult for lawyers because oftentimes we have a client who's a person of color, and we have a client who doesn't speak maybe perfect English, but the jurors come in and we want to make sure that we have a balance of people who do, as close as possible, look like the client, right? We want fairness. We don't want bias. We want fairness. So we are prepping your case to go towards trial, and that might take a year, that might take longer. Things vary based on how many cases does your lawyer have? What is the other side doing from the defense side in the insurance company? Are they moving fast? Are they moving slow? It's not always possible to know how the case is going to go, but things are getting better after COVID when we weren't able to go to court and everything came to a stop. And then I remember being in court in 2022 and my trial date was set for 2024 and my jaw dropped. My poor client has to wait a year and a half to get to court. That meant to the insurance company, they could just kick back, put their hands up, and that's exactly what happened in COVID. They did not feel rushed. Things are changing for the better. So before you ever go to trial, because many people are afraid of trial, many people don't want to go to trial, they've heard bad things about trial, and other people have heard great things about trial because maybe they knew someone who took it all the way and they won. But many people are afraid and they're nervous, and they also would rather know how the story ends, and that would be something called mediation. Mediation is a powerful tool because you, as a client who's injured, gets to decide and have a sure thing wherein you settle your case. It's much more informal, and you sit with your lawyer at a very nice office, typically in downtown San Francisco or Walnut Creek. Lunch is provided, and you sit with someone called a mediator, and it can be a retired judge. It can be a very experienced lawyer who's been practicing for many, many decades, not many decades, but many years, 20, 30 years, and they've handled thousands of cases. And you pick this mediator to hear both sides, hear what the best evidence is from both sides, hear what the worst parts of your case are from both sides, and then they try to help you come to the middle, which makes both sides usually not so happy, but happy enough to settle. Because at trial, you're not going to know what the jury's going to decide. That's the bigger gamble. But mediation is where a good majority of cases resolve. Probably, Isabelle, you can chime in, but probably over 90% cases resolve before trial. Would you agree?
I do agree. For one point though, you can settle your case at any time throughout the process, from the claims process, from the litigation process, right? And throughout the whole thing, there is always a balancing of whether it's worth it to move forward, whether they have given you a good enough offer even before mediation. But Rosie is correct. Most cases settle by the time they go to mediation. Whether it's before mediation or at mediation, most cases do settle.
Yeah. And I think that one of the beauties is that my prior experience as a prosecutor, I wasn't there very long, but what I knew was that the hardworking prosecutors, unlike the not so hardworking prosecutors, were the ones that the defense attorneys feared the most, because they were always working up their case towards with an eye of trial. They would talk to witnesses. They would talk to the detective, the investigating officers, whoever they needed to, the victim of the crime. They were talking and talking and talking to these people, even to the family of the victim. And they were like, I could go to trial tomorrow if I had to. And defense attorneys can pick up on that. They can sense a lawyer who's really doing the work. In this business of personal injury, it isn't any different. And what I saw was, as a prosecutor, you handle so many cases every week, And when those defense attorneys fear you and they're willing to resolve and settle those cases, which is also at about 95 to 98%, people don't go to trial in criminal cases. They plead guilty and they go to prison. But it's always going to happen with the lawyers who work hard. They're working up their case. They're diligent. They're not letting things fall off. In personal injury, it's no different. If your client says, I'm going to take a break from treating, you want to know why. Because if there's a break from treating, the insurance company is going to say, oh, you must be better. You must be fine. You must not have any pain. However, that's not necessarily what that means. So always be communicating with your lawyer what's going on. Some people are going to be exhausted going to all those appointments and they have other responsibilities. They have a child with a disability. Their spouse is ill with cancer. They don't feel they can put themselves first. I mean, any number of things are happening in people's lives. And as lawyers, you really get to know your client. You don't force them to do anything, but you have to understand what they're doing so you can then work with that. So you're always working up your case towards trial, which can help in mediation. Because when you go to mediation, you want to hold a couple cards back. You want to hold a couple big cards back. I've learned from my mentors who are retired from personal injury, who practice a little bit after 40, 45 years, and they'll say, I held 1 or 2 chips back, showed it to the mediator, and the mediator said, let me go take that to the other room and see if we can't move the dial up on what they're offering as far as settlement. And sure enough, $100,000 extra goes on the table because of that chip you held back. So I'm always listening to my mentors because they've already done it. They've already succeeded and they've retired comfortably. So you have to know that mediation is a time where you have to really trust your lawyer, but you've been building that relationship from the first day, that relationship with your lawyer, that communication, that honesty, and when you have questions and you have concerns. Because another thing to touch on what Isabelle said, not only can you settle your case whenever you want, you're the boss, you're the client. I never force a client anything, and she doesn't either. But the other thing is you can also change lawyers, and that happens often. People change lawyers because they can't get the lawyer on the phone. They only talk to the paralegal or the secretary or even just the receptionist. She doesn't know what's going on in your case. She doesn't have any legal training. He doesn't know what's going on as a paralegal. Maybe they know some facts, but the lawyer is the base person you need to speak with. And there's clients who cannot get a hold of their lawyers, and therefore they switch and they go to another firm. It happens. Lastly, if you do not settle at mediation and they do not put the amount of settlement money on the table that you're happy with and that you feel your case is worth from everything you've been learning over that 1 year, 18 months, however many months, because you're becoming very educated in this process through your lawyer and the law firm, is that you can go to trial and you can go take your chances with the jury, and the jury award can be phenomenal. It can also be much smaller than you wanted, but you might say, I had to go for it because they weren't respecting what I've been through, how I've changed, how my relationship with my spouse has changed, or my children, or being able to play with my grandchildren is something I get a lot from elderly people. I can't play with my grandchildren anymore. So you can go to trial. You can go for the jury award and judgment that you want. Lastly, so this slide talks about when you get your verdict and you won and you got, let's say the policy was $500,000 for that farmer's driver that hit you and ran a red light or drove drunk. You get your settlement, and now you do pay your lawyer. Your lawyer gets paid, your medical bills will get paid, your lost wages are a portion of what you're going to get. That's the balance of the money after your medical bills are paid, your lawyer, and I should add your lawyer's costs. So your lawyer was spending money throughout the case on various things. When I talk about filing a lawsuit, that is going to cost about $500 to the court. The lawyer's typically going to pay that, as opposed to asking you, injured person who missed 6 months of work, can you give me $500? No, the lawyer's going to cover the costs. They're called costs. And there will be other costs that'll come up. Ordering all those medical records typically is going to cost hundreds of dollars because we're going to get official copies from Kaiser, from Sutter, from Highland or Children's Hospital or Stanford. We're going to get copies, and it's a lot of copies of records for your treatment. Those are costs we're going to pay. So going to mediation, that's a cost. That can be anywhere from $2,000 to $5,000. Again, we're not going to ask our client to pay that. We're going to pay that, but we're going to recoup that at the end. And there's a risk here. If we lose, whether it be at trial or if we lose because you decide to give up, typically lawyers have a contract that says we hold you harmless. We're not going to ask you for the money we put in. There are some lawyers that might ask you to contribute to costs as the case is proceeding. But there's a lot of lawyers, myself included, we don't ask you to cover those costs. Why are we taking that risk? Because we do the analysis up front early on, and we are under the impression that we can win this case. What we can't guess is how much in the very beginning, because we haven't seen all the records. We haven't seen how long your treatment's going to go on. But we can guess and estimate this is a winning case. This is not a case we can win because there's no insurance. So that's why we take that risk. That's why we pay those costs. We pay the court fees. And then you get the balance and you will get the majority of the money. There is a misconception that, the lawyers always win and they get the majority of the money. Most personal injury awards are not going to be the lawyer gets the majority. It's going to be the client who was injured, who suffered. You will get the majority of the money left from the check that was paid by the defendant. The last bullet points here are simply, if you lose, I already covered that typically the client does not pay, and that's stated in the contract. We get paid if we win. We do not get paid if we lose. And you see that on billboards all over the freeways. You only pay us if we win your case. And that's true for most personal injury attorneys. But it's case by case. Lawyers can do different things. And that's a great thing to ask a lawyer when you're having that first consultation. What would happen if I lost? What would happen if we stop and don't proceed and you've paid some fees and costs and filed with the court and I decide to move away and leave the country? It could happen. So those are good questions. Don't ever hold back. Don't ever ignore something that's of concern to you, because we've heard it all and we want you to feel confident that you understand what's happening, because that's really important to lawyers. You should know what's going on.
All right.
I'm done.
So basically,
Sorry.
as a recap of everything that you've learned in this last hour, it's pretty simple, right? Personal injury is something that happens where you have an injury to your person, whether it's just emotional distress, a mental anguish, or an actual physical injury. And it is caused by somebody through no fault of your own, then you might have a case. You've learned about the different possible types of personal injury cases. Everything from car accidents to slip and falls to medical malpractice, product liability. If you have even the smallest inkling that you might have a personal injury case, I would highly recommend that you call an attorney. Even if you just get a short consultation for them to say you don't have a case, or they might say you do have a case. Let's talk about it a little bit more. And then the second point, the statute of limitations is important. Don't sit on this, okay? You have mostly 2 years for different types of personal injury cases. Sometimes it's as short as 6 months if a government entity is involved. And you know what? Sometimes it's just worth asking, because you don't know if the person that hit you was driving a government car or worked for the government, right? It might not seem like a government case, but it is. And if you've let 6 months pass, there's no way to kind of, there are some ways, but it's a very difficult way to kind of go back and backtrack and turn back the time. And the third thing, you buy insurance to protect yourself, right? The defendant, the person who's hit you or the company who has caused you an injury has insurance to protect them too. So it is definitely worth exploring. Don't be afraid that the little old lady that might have hit you is going to go bankrupt, right? There are laws that require us to have insurance, and it is certainly for these purposes, right? To protect the public, to protect yourself. And then speaking of insurance, Rosie talked about UM and UIM insurance. And I am a firm believer of that because I have had a personal experience with that. My mother was hit by a drunk driver, and that person did not have any insurance. My mom had a brain bleed. She was in the hospital for 7 days, and the man who hit her had no insurance. However, she did have uninsured motorist insurance coverage on her own policy. That coverage allowed her to pay medical bills, to get through not being able to work for a little while, and paid for her pain and suffering, right? So I am a firm believer, not just because I'm a personal injury attorney, but because my mom was an actual beneficiary of UIM coverage. So please take a look at your declaration pages and see if you have it. If you have any questions,
Oh, and we
give
forgot
Rosie
to
and
say,
I a call.
and we
can take
forgot
a
to
look at
say,
it.
yeah, sorry, we forgot to say, call your insurance. If you really don't know, I have clients where I step out of the room, then I come back in 5 minutes and they called their agent. That's usually a friendly person at State Farm, Farmers. They have your homeowners. If you own a home, they have your cars. You know, they want all your business, right? And so you call them. I step out and they say, you know what? I only had 25,000 uninsured motorists, Miss Torres. You stepped out. I increased it to 100. From here forward, I'm good to go. And then they're really happy for that advice. You know, there's no pressure to sign up. It's just make sure you're safe because of what you just heard Isabelle say. And then we continue the consultation because I want them to do it right then and there. Walk out of here with something better in your life, which is more uninsured coverage, honestly.
And finally, I honestly believe that choosing the right personal injury attorney is the key to getting the case, not just whether it's settled or goes to trial, but getting the value for the case.
That's right.
Right. And while we talk about, your injuries in terms of value, in terms of money, I wish that there was a way that I could say, Shazam, that bone never broke.
Right.
Shazam, that person that you love never passed away because of somebody else. But there's no way for us to do that. The only way that we can help make up for that, unfortunately, is through money. And that's why we call it value. That's why we talk in dollars, right?
Yeah.
But that basically is the gist of, what it is to have a personal injury claim. If you have any other questions, feel free to contact Rosie or myself or anyone on FBANC's directory who handles personal injury cases.
Yeah. And I forgot to say one last thing. I hope it's okay. It's a little past time, is that one of the things that I love is that I speak Spanish, and that's why I left my government job. My prosecutor job was great. I was a mother, a young mother with a baby, but hablando español is not something that happens when you work in government. So I had to go out on my own to utilize my language. So whatever language, that your family comes from, find an attorney you feel comfortable with, because that's going to be really important. You're going to be with this lawyer for a while. So you want to know you're going to have a relationship. So that's one thing I enjoy, is using my language, my culture, my background for my clients. And it gives me so much joy to help them understand what's happening, because it's a complicated story. What's going to, it's a complicated process.
I agree. Thank you so much for your time.